बात तो हम तारीफ तारीफ सुनने के बड़े शौकीन है, हमें बुरा नहीं लगता है। बस thanks my dear friends. Thanks my
It's
dear friends.
very elaborate.
Nothing is going on. Thanks my dear friends. I want to start further.
Sir, your technique is unique, sir.
बस तारीफ. Yes, my dear friends. As you know that whether document is showing or not on your screen.
Yes, sir, we can see.
Yes,
It's a
sir.
Yes, sir.
visible.
Visible.
तुम लोग इंग्लिश सुन करके हमें भी कॉन्फिडेंस आ जाता है कि चलो हम ना इंग्लिश बोल पाए लेकिन बच्चा तो ठीक बोल ही लेता है. As you know that my dear friends, good evening to all of you, and I am going to start the topic that is the school of Menseria, that is the interpretation of the institutes. As you know that this is also the philosophical questions and this is relevant only for the purpose of UPSC exam and for the purpose of understanding. It doesn't require for writing the semester exam. So if you are interested, you can listen, otherwise you can enjoy. Here the school of Menseria, I had developed this school. I had tried to search. As you know that interpretation of the institutes. In the interpretation of the institute, we can take the help of these points. Do you know institutes? For example, I am taking example of the IPC. In the IPC, sections can be divided into two parts. For example, total section is 511. How can we understand these points? We can understand these points into two parts. Some sections which clearly talks about guilty mind, जैसे whoever does any act with intention of causing death or with intention of causing such bodily injury it is likely to cause death. It means they clearly 299. If you read 299, it clearly says that whoever with the intention of causing death, comma, मतलब intention of causing death clearly denotes that there are two ingredients of the section 299. First is that whoever does any act with does any act means this is the actus reus with the intention of causing death. Intention, this is the mens rea. It means there are some cases in the IPC where law clearly talks about the actus reus and mens rea. On this point, there is no controversy regarding the interpretation. Every judges will interpret on these points, and the judges had no choice except to interpret as condition has been mentioned this. Okay. Here the institutes clearly talks about mens rea. For example, you can take 299, 300, 378. Only these are the examples. Here the judges has no place to apply his mind. Okay. But come to the other category. Other category is that where law talks about only one thing. Law talks about the actus reus. Okay. But on the point of mens rea, it is silent. On the point of mens rea, it is silent. Okay. Now question arises. Whether condition of mens rea is required or not. Whether the condition of mens rea is required or not. This is the big difference. Controversial point is here. For example, institute clearly talks about the mens rea, first point. Here the second point, there is no controversy, each and everything is fine. But second point regarding the institute is silent. Where institute is silent, what would be happened? For example, 121, 375, 494, on these points, institute is silent about the mental status. To solve this problem, there are two schools. One school talks about a presumption of existence, other school talks about the absence. It means here fighting between the judges starts. Here the one judge said that if the law is silent, in that situation, we should apply actus non facit reum nisi mensit rea. Said that if law is silent, in that situation, we should apply the maxim actus non facit reum nisi mensit rea, and person can't be convicted without guilty mind. But on the other side, like the Justice Blackburn, he said that no. How can you say? How can you apply? How can you say that if law is silent, mens rea is necessary? He is asking no. Judges can only interpret the law. Whatever law is, only interpret the law. Don't try to insert new condition. This is the big fighting between the judges. It means one side, there are 10 judges. For example, 10 judges said that if law is silent about the mens rea, एक बात और बता दूं, law on the point of actus reus will never silent. Law may be silent only on the point of actus reus. If law is not silent, no problem. If law is silent, fighting start between the both sides. Here, this is the point. Now, there are 10 judges who saying that if law is silent on the point of mens rea, actus non facit reum should be applied. On the other side, like Justice Blackburn said that no, if law is silent, you can't apply such maxims because judges can only interpret the law. Judges can't insert new conditions. Now start fighting. In this fighting, I will cite 10 judges from this side and I will discuss 10 judges from this side. यही point law में जो समझ गया, whoever had understand these points, he will be master of the criminal law. Regarding the other question, regarding the bigger provision, you can get everything in the book. There is no need of the teacher for other provisions. But for this point, you have to follow your teacher. Fighting start. First of all, I will discuss presumption of existence of mens rea. If law is silent, judges say that you have to apply this maxim. For example, R versus Tolson case, Siraj versus D. Rudigen case, Justice Bredd versus Wood case. These three cases, these are the mandatory questions, and 100 times questions had been asked in the objective questions everywhere frequently. Keep in mind. If you don't believe, you can see the previous year questions paper of the UPSC. I have the each and everything. You can see, you can observe. Here there is one side. For example, here this is the point here. For example, 5 cases. In 5 cases, honorable courts of the Britain and India said that if law is silent about the mens rea, judges can introduce actus non facit reum nisi mens rea maxim and can require mens rea. It means person can't be applied with guilty mind. Fowler versus Fawcett, who had decided? Lord Kenyon. When decided? 1798. See the chronology. I never write without following the chronology. It means anyone is writing without following the chronology, he doesn't know development of the law. Law is like a baby. Baby come in the womb. I was saying like this. Baby came in the womb. Then he became the 1 year, 2 year, 10 year, 20 years, 25 years. But you are going to say that in 20 years he completed the graduations. After you are saying that in the 15 years he completed the high school. After the 25 years he completed the LLB. He took the birth in 1985 like this. What would be happen? He will become very angry. How are you elaborating? Please say in a systematic manner. When I took the birth, what are the primary educations, graduations like this? This is the proper manner to narrate about me. These are the point. Other side is fighting here that judges are saying that if law is silent, in that situations, maxim should not be applied. Mens rea does not require, and person can be convicted. In this category, main judgment is that R versus Prince, Ranjit D. Udaisi versus State of Maharashtra versus M.H. George. For example, here boy was knowing that she had attained the majority. He did in good faith, but even he was convicted. Why he was convicted? Do you know? Because law was silent regarding the guilty mind. And Justice Blackburn said that if law does not require guilty mind, I can't insert new condition guilty mind. That's why he was convicted. That's why person was convicted even without guilty mind. Ranjit D. Udaisi case, he was a bookseller. He was selling the Lady Chatterley's lover book. He was not knowing content. He was not much more educated, but even he was punished for selling the prohibited book under section 292. Why? Court said that, Mr. Ranjit Dudasi, 292 is silent about the mens rea. If it is silent about mens rea, I can't insert this particular condition in the 299. Is the same situation in state of Maharashtra versus MS George? Same situation was applied. It means it totally depends upon the mindset of the judge. Totally depends upon the mindset of the judge. Some situations, some judges who are liberal, who are in favor of the accused, he applied the maxim. Some judges are very strict, they are in favor of the victim. In that situation, they will not apply this maxim. So, my dear friends, these are the two schools which are the important. And as you know that on the other side, where the presumption of absence of mens rea, you can see R versus Prince, 1875, 1910, 1964, Indo-China Steam Navigation Company case, Hidayatullah National, like this. So it is my humble request, whenever I will discuss the state of Maharashtra MS George case thoroughly, I will discuss all these 5 cases. I will also discuss all these 5 cases. It will be matter of hard debate on both the sides on the point. As you know that there is a shortage of time, and I have to read because only 2 classes had been prescribed, and I have to start the case in the proper manner. That is my humble request. You can remember, you can read meaning of intention, knowledge, motive. Okay, these points you have to read. Just 2 minutes or longer. I will take only 2 minutes. I know that I am crossing my limit, but only 2 minutes. Intention, knowledge, motive. It is a big difference. And if you go your semester exam, you can see the question. In the 2010-13 question was, write short note on the 2 of the following. Explain and illustrate distinction amongst motive, intention, and knowledge. What is the difference between motive, intention, and knowledge? As you know that here the 2010-13, and I had made the differences with the help of charter, with the help of ground. In the same situation in 2016 question was that we discussed the difference between motive and intention, and this question was also asked in 2016 other questions, differences like this. So it is my humble request that each and every year there is one question regarding the difference between the intention, knowledge, motive like this. But as you know that for a better understanding of the subject of the IPC, students can't understand the IPC without knowing the difference between intention, knowledge, and motive. And the time is over. In the next class, I will discuss the differences between all these things. And thanks everyone for appreciating me.